Hello everyone. Thank you for coming to the JPA seminar. My name is Satoko Endo. Today, I'm going to talk about the 2021 revision overview for the granting of relief procedures. Following this flow, Japan's intellectual property system has been revised 4 times so far with regard to relief after the expiration of the term. These amendments have relaxed the time and subjective requirement, increased the number of procedures covered, and ensured sufficient protection of right. However, even with these amendments, there are still 2 issues: strict interpretation of a legitimate reason and the procedural burden on applicants. In order to resolve these 2 issues, a 5th revision was made in 2021. First, I will explain strict interpretation of a legitimate reason. Upon accession to the PLT in 2016, Japan adopted the recovery standard of due care and decided to maintain the legitimate reason criterion, which was established in the 2011 revised law. The recovery standard of due care was adopted instead of unintentional, because it was thought at the time that if unintentional were chosen, the range of remedy would be too wide, which might lead to abuse of the system. The IP system of the JPO currently operates under strict interpretation of a legitimate reason. But it had been pointed out that this practice is too strict compared to other major countries. Please take a look at this table. This shows a comparison of right recovery system between Japan, the EU, France, and the US. The highest acceptance rate is in the US. It falls within the range of 19% to 95%. The lowest is Japan. It falls within the range of 10% to 20%. Here, the US has adopted the recovery standard of unintentional. On the other hand, in Japan, due care has been adopted. Then this result is easy to understand, considering that if the requirement for the restoration of right are relaxed to unintentional, the restoration of right will be easier. The EU falls within the range of 60% to 70%, and the acceptance rate in France is around 80%. It's interesting that even though the EU and France have adopted due care, the acceptance rate is high. The reason for the low acceptance rate in Japan is not clear. However, I think that due to the strict interpretation of a legitimate reason, there is no room for recovery of right for expired period caused by human error or mistakes in procedure management. Next concern, the procedure burden on applicant. An evidential document supports the matters presented in the statement of the ground for restoration and its mandatory submission in Japan. For this reason, it has been also pointed out that the work of preparing document is a heavy burden for applicants. In the EU and France, an evidential document can be submitted voluntarily. In the US, in principle, the submission of an evidential document is not mandatory. Only a written statement may be submitted. Based on the above, in this situation, when you can obtain right in other countries, it assumes that only Japan will not be able to sufficiently protect its right. Therefore, in order to increase the the acceptance rate, legitimate reason required under the current law will be revised to unintentional. And in order to reduce the burden on applicants, the submission of an evidential document will be revised to not mandatory. Please note that even if it's before the effective date, in cases affected by COVID-19, the submission of an evidential document is not mandatory. In addition, please also note the following points. The date of enforcement will tentatively be April 1st, 2023, but this date is not fixed yet. New relief target added by this revision are below. Human error, procedure management error. There will be a charge for procedure, but the specific amount is to be determined. The reason that a fee is charged are to prevent abuse of the system and to encourage compliance with the procedure period. For this reason, the JPO has decided to impose a uniform recovery fee regardless of the size of the company. Lastly, there are 5 points in this revision. Legitimate reason under the current law will be revised to unintentional. The submission of an evidential document is not mandatory. New relief targets have added. The effective date will probably be April 1st, 2023. A recovery fee will be imposed. In this way, the provision for relief after the expiration of the period have been relaxed. It will become easier to obtain and maintain rights in Japan. So please take advantage of this. That brings me to the end of my presentation. Thank you.